Hello, everyone, and welcome to the PCI Practical Matters podcast, keeping you up to date on important topics in government contracting. Today's topic is Top 10 Mistakes in Contract Administration, Part 2, and our speakers are Fred Geldon and Tyler Evans.
Hi, I'm Fred Geldon, and just by way of introduction, I'm a government contracts attorney at Steptoe & Johnson, as is Tyler. My prior experience, back when my hair was dark, includes 21 years of electronic data systems, where I managed for most of that time the contracts and legal group, and we encountered and dealt with and sometimes made some of the mistakes that we're going to talk about today. This is a continuation of part 2 of our Big 10 mistakes, and just spoiler alert, we actually have 13 mistakes. So who knows where there may even be a part 3. Tyler?
Thanks, Fred. And just quickly, as Fred said, I'm a partner at Steptoe & Johnson as well in the government contracts group, and I've been doing private practice for 11 years in government contracts. So we can kick it off. We did 4 last time, and now we can go into number 5.
Okay, last time we focused a lot on terms and conditions, and we kind of emphasized that the statement of work is something the contractors often look closely at, don't have quite the same potholes that they step in, but maybe that's being a little too generous. We do have problems with the statement of work, especially when contracts and program don't always match on the government side. Tyler, have you run into that with your clients?
Yeah, absolutely, Fred. And I think it is fair to kind of start with that issue of the technical side, the program side, and the government and the contracting side potentially. We talked a lot about that in the first session, how there's sometimes a disconnect. But I think here the point that we emphasize is that the disconnect is not necessarily because, I mean, it could be, but it's not necessarily because there's a disagreement or anything like that. Often the technical side might not have looked at the statement of work in 2 years, right? They just might not really understand kind of what's in there and what the very specifics are about what the contractor has to do. And then when they ask for something that's a little bit different, they get into a potential situation where they have to pay the contractor for additional work or change the schedule, whatever it is, all depending on whether the contracting officer agreed, right? We talked about authority and all those types of issues last time, but that kind of disconnect can really happen between the technical and contracting sides, even in the statement of work, because they just might not be looking at it that closely.
And then the contractor can get caught in the middle, and sometimes it really becomes a matter of what problem do you want to live with? If you say to the program, well, I'd love to be able to do that, but it's not in the contract. If you're really working toward the rule, you may be contractually protected, but that's not a good relationship builder. On the other hand, if you want to exceed your contract, your customer's expectations, and basically jump through the hoops without having the contracting officer on board, well, then you have the problem of potentially doing a lot of work as a volunteer and losing money. So it's a delicate balance to try to do that. I don't think there are any formulas.
I think that's right, Fred. And it comes down to the company and the relationships at issue, because I've definitely seen it go both ways, where you're stuck between the two, the kind of technical side and the contracting side. And maybe you just have a great relationship with the technical customer, and so you just decide, look, you know, the contracting shop, we can live with them kind of being a little bit upset with us. But at the end of the day, the contracting shop is the one with authority and disputes and issues like that. And so you don't necessarily want to kind of burn that bridge as well. So charting a middle course can work, but it's definitely a hard decision. And I've seen some situations where the program side just keeps even back channeling to a contractor and saying, look, we think this is a problem. We don't know why contracting is insisting on letter of the contract, that kind of thing. And it really does place the contractor in a tough position. And that's where I think you had talked about last session, Fred, that maybe you can talk to the technical side and come up with a kind of plan to go to the contracting officer together and propose a resolution.
Yeah, we've run into situations where the contracting officer, where the program shop says, oh no, we don't want to go to the contracting officer. All they do is say no. You know, and again, it's in fairness, they don't always have a reason to be working together in terms of physical proximity, things like that. And they have different clients that they look to, different interests, even though they're in the same government.
Yep, absolutely. So I think with that one, maybe we can go on to the next mistake, Fred, and this is common mistake number 6. I didn't pay attention to the details. So the details of the contracts, we've talked about the specific contract terms, you need to know that, the statement of work, that kind of thing. What are some other just very nuanced things in government contracting that are important to think about, but you still can get burned on if you're just not paying attention?
Yeah, I mean, the devil really is in the details. A lot of it has to do with financial requirements, the Service Contract Act, Davis-Bacon. Sometimes the prevailing wage rates will change and you need to be on top of that. The requirements for compliance, some of the program requirements for your compliance plan have to be dealt with and again documented. And then if you have a GSA schedule or a VA schedule, you've got all the details in the most favored customer provisions, the price reduction clause, where you have to not only be submitting all that information, all the commercial practices information right up front to be on the schedule, but then you have to keep it current. And when your catalog changes or your basis of sale customers, there's a new change to that, that requires a disclosure. Now, that's a detail that can be described as a detail, but it's really much more than that because it's also a practical management problem. If you're not so much with the catalogs, which are a little bit more straightforward, but if you're dealing with commercial sales practices where you've got salesmen all over the state or all over the country, you need to know what they're doing because what they're doing may be inconsistent with your disclosure requirements and may require updating. For example, you've got some description of when you give customer discounts, and then you find out that your salesman out in Boise, Idaho has a new customer and is giving a special discount to them, and maybe it's not a coincidence that it's the end of the month and it's going to help him meet his target. Those are details, but they're details that can get a company in serious trouble because when you have failures to disclose things that are required, it's not only a contractual failure, it can potentially turn into a False Claims Act failure and potentially a criminal situation.
And Fred, I think it's the False Claims Act piece there that I always like to emphasize as well. Given everything you just said is I think the key point, but then also another issue that I see kind of an ancillary point from time to time is people dismiss certain requirements as kind of that's just dotting your I's and crossing your T's, right? It's just really in the weeds in government contracting. But some of these requirements can be referenced, I've seen kind of by whistleblowers, right? People looking for problems outside the company, inside the company, that kind of thing. And so examples that I've had direct experience with, there are requirements in life sciences contracting, for example, where you have to disclose certain financial conflicts of interest and things like that. And there's a requirement to post your financial conflict of interest policy online on a public website. And most contractors don't end up doing that. But then you get some letter from somebody who says, well, look, I did a search on these companies and figured out that you all were not complying. And it just kind of snowballs from there. I think another one that I've seen is you make the kind of standard reps and certs that people make where they just sign off on the system for management and just say, well, yeah, clearly none of our people are suspended, debarred, criminally indicted, those kinds of issues. But they don't actually ever go confirm necessarily with their principals or something like that. And you can get into trouble there too, because the definition of principals for a lot of those representations can be pretty broad and can even extend to some owners. And so you do kind of really want to make sure you understand some of those dotting your I's and crossing your T's, because they can still lead to problems, I think, later on.
Absolutely. Let's move on to the next one. And now we're actually going into some of the contract administration failures and problems that are maybe a step above the basic. So let's talk about constructive changes. Have you encountered clients who don't really deal with that appropriately?
Yeah, Fred, I think that's a good point to talk about. And it's one of the most common issues if you're going to have some kind of dispute between the contractor and the government. And so the exercise of the changes clause, you had mentioned that last session, where the government has a unilateral right to change certain aspects of the contract. That is pretty straightforward, right? You have kind of a process where there's an equitable adjustment, a change in contract price or schedule based on what the government is telling you to do. And a lot of times that will come with the formal, standard form on the front of the modification, and everybody kind of knows what's going on. But if you have this situation where, again, the technical side is maybe telling you something, and you ultimately get authority from the contract officer who's kind of saying, yeah, that sounds okay to me, that kind of issue, but you're now doing additional work outside the scope of the contract, or you're getting delayed by the government, you're being told you have to speed up, all those kinds of issues. If you don't respond to that and know how to handle constructive changes, you can waive your rights to get that kind of equitable adjustment and essentially be doing, as you often say, free work, or volunteer work for the government without kind of getting compensation for it.
And let's make sure everybody understands what constructive changes are. As Tyler said, the government has the right to make changes unilaterally within the scope of the contract. Those are the directed changes. And what a constructive change is basically something the government does or fails to do that increases the contractor's problems, their costs, their delays in time, etc. But it's not something done officially as, here I'm making this change, or this is a new requirement. And if this were in a commercial contract, it would be treated as a breach of contract, and we would have a lawsuit on that basis. In the government world, there is this concept of constructive change, meaning, well, the contracting officer didn't actually make that change, but because they had the right to make that change, we're going to treat them as if they did. Now, the problem with that comes with recognizing and having the whole team recognize when there is something which has increased the contractor's burden, increased their cost or the time needed, where it's not being flagged. It's not being, you don't have these balloons that say, guess what, we're making a change, here's the contract mod, try to price it, whatever. And that leads to a basic problem of, when do you spot the change and what do you do about it? As Tyler said, you need to be controlling it, you need to be managing it. And if you discover that, hey, the Corps has just told us, the program manager has just told us to do this, and we don't have contract authority and so on, well, that's a constructive change, but you recognize it early on. If you recognize it early on, it's much easier to resolve. The money hasn't been spent. We have alternatives. We can go to the government and say, we'll be glad to do it, but understand that changes what our burden is, and we need to change the price accordingly, etc. But all too often, what really happens is that there is a change. There is something which is a constructive change. The government has, through the program, asked you to do some things that weren't really in the contract, and maybe they're subtle changes, but they add up. Or the government has failed on its part. Maybe instead of approving your proposed work and taking 2 weeks to do it, they took 6 weeks to do it. And those are not formal contract changes, but they can really badly affect the contractor's performance. And if you wait until all of that happens, and you only discover it because you're looking at a quarterly report and realize that you've spent more money than you thought you would, then you've got a different kind of problem, because the money's been spent. Once money has been spent, then somebody's going to have to pay it. Nobody's going to be happy about that. And what you don't have is the alternative of saying, let's not spend the money, let's do things differently. If a contractor identifies something as extra work before it's done, they have the option of saying, contracting officer, this would be a change to the contract, and we'll give you a price proposal, and you have the option of deciding not to do it. But once it's done, the money's been spent, you don't have that option, and it's a much harder situation to resolve.
Yeah, and Fred, I think the one that I see most often missed. So a lot of people may be training people working on the contract to say, okay, if they tell you to do additional work, let me know. And that's still hard to get everybody on board with that, but that's usually the most obvious one. But you had mentioned delay in the government approving reports, and that comes up frequently, where a government delay can be a constructive change because it changes your cost or your performance schedule or whatever it is as a contractor. And it's definitely a situation where there are instances where it even comes to a breach of contract. Everybody's upset because the contractor is 6 months behind, that kind of thing. And if the contractor is then saying after the fact, well, my defense is you all were late too, and that's what caused me to do it, that again becomes a post hoc issue that isn't given a lot of credit, and there's a big dispute about that. Whereas if you had just said up front, look, you're delaying things and that will delay us, that could save you a lot of headache later on.
Absolutely.
All right, so then moving on to mistake number 8. So bad communications within the purchasing department. So we try to focus on the government and the contractor here, but I think this will be a contractor issue alone. And Fred, you have the most experience, obviously, with your many years in-house on this. So what are some examples and pointers you could add to here?
Well, I'll give you a couple. One of the issues that we ran into, EDS was a company that, while we had a big government contracting arm, it wasn't a government contracting company. Primarily, it was a commercial. Our customers were more commercial, and the company centralized its purchasing function so that the same group of people were doing purchasing for both government and commercial business. Not surprisingly, they weren't very sophisticated in what the government business requirements were. So predictably, we would have issues where flow downs had to be put in, where some of the terms that might be acceptable in a commercial subcontract weren't in a government contract, and so on. So that became a communication problem, exacerbated by distance because we were in different cities and different states. But there was a more subtle kind of problem that we ran into, which was not the fault that I've described, not caused by that, and that is the difference between a commercial prime contract and a commercial subcontract. And by that I mean a prime contract for commercial items under Part 12, or it's now commercial products and commercial services, has a much more limited number of FAR clauses and requirements and flow downs and so on. Sometimes there will be a prime contract that is not a commercial items contract. So it has the full gamut of audit clauses, et cetera. But the FAR encourages prime contractors to issue subcontracts that themselves are commercial where that's appropriate. And so we'd have a situation where the prime contract is not commercial, but the subcontract is. And so our team in Texas would be saying, well, this is a commercial subcontract and we're dealing with Cisco or Intel or some commercial company, and they are not willing to accept these government flow downs. And my prime contract administrators for a while were not realizing that that was in fact the right answer. And instead they were saying, well, wait a minute, we have all these clauses in the prime contract. They have to flow down to the sub. Well, no, they don't. And there was an interesting kind of dispute where I was in the middle of it and resolving it. And actually, because I resolved it successfully, I became the hero to all the purchasing folks in Texas. But that's a failure of communication, or necessary communication, between the folks doing prime and the folks doing sub. I should add that we at an earlier time, had both on the same team, where we had a team of people dealing with the same customer in the same contract, and some had responsibility for prime contract administration, some for subcontract. And that worked much better from that standpoint. Now, the company made the decision to centralize, and that had its pluses, I'm sure, but it also had that drawback.
And Fred, another big issue that comes up in this, so let's say you've had that discussion with the purchasing department, people in Texas are happy with you, and everybody understands that you have more limited flow downs for commercial item subcontracts, and that's fine, that's okay, right? But on the commercial item, commercial products and services now, and the non-commercial side in subcontracting, what do you do when you encounter situations when somebody says, well, the subcontractor says only flow down the clauses in 52.246, the commercial item subcontract clause, that specific list that is only applicable. Are there other provisions that people should be thinking about it as flowing down or needing to be flowed down as a matter of discretion to protect their companies?
Absolutely. Because the FAR provides there are certain mandatory flow downs in commercial subcontracts, and allows, doesn't require, but allows contractors, prime contractors, to flow down others as necessary. And for example, two major examples of that are the changes clause and the termination for convenience clause. Those are not mandatory flow downs. That surprises a lot of people because they're such fundamental government contracting clauses. But the government basically doesn't really care whether the prime contractor has protected itself by flowing down those contracts. But the prime contractor should care, because if it doesn't flow down, think of what can happen. The government makes a change within the scope of the contract to the prime contract, and that change affects the work share of the subcontractor. Well, does the prime have the right to change the work share of the subcontractor? If it doesn't, then it may get stuck paying for things it no longer needs, or it may be breaching contract in some other way. It basically needs the right to say to the sub, our prime contractor scope has changed, so does the subcontract scope. Now, the sub doesn't have to accept the clause as written. The sub can take the position, well, we respect that the government might change your prime contract, and we will accept the flow down of changes that are required that way, but we're not going to give you an unlimited right to make changes if it's not something that's prompted by a government change. And a similar example is the termination for convenience clause. Just like same situation, you've got the government having the right to terminate the prime contract for convenience, and if the prime doesn't have a similar right in its subcontract, it can get caught in the middle. And unless it needs the subcontractor's supplies for some other contract, it may wind up breaching the contract by saying, we don't want any more. And again, the subcontractor could take the position, and it's a defensible position, that they'll accept a T for C clause only if it's limited to the government terminating the prime contract or that part of the prime contract that affects the sub, but not making it unlimited where the prime can say, okay, we just found a cheaper supplier, you're out, they're in. But those are definitely two of what can be many business need clauses that should be flow down, even if the FAR doesn't require the flow down.
Yeah, and I think that compromise of kind of will terminate to the extent the government terminates, right, is something I've seen frequently, and is a good way to handle that relationship between the two parties. And the other, like you said, there are many things we could reference in this area, but government property issues and sourcing requirements. So if it's the Buy American Act, Trade Agreements Act, some restriction on specialty metals, whatever it is, those are ones that often inadvertently get left out and are very critical, because the prime contractor is delivering items to the government, needs to make sure that the subcontractor is helping them to meet those goals, I think. So I think with that one, do you want to move on to the common mistake number 9, Fred?
Yeah, this is the one that involves the animal, the sleeping grizzly bears.
So I always love how you say let sleeping grizzly bears lie instead of let sleeping bears lie. It emphasizes the importance here. But essentially the issue here is just letting something go and realizing there's a problem, but hoping it goes away over time. And almost never that generally does not occur. And I think, this is an area where a lot of people just say it's a small issue right now. The government doesn't know about it. My manager, the contractor, doesn't know about it, that kind of issue. Or on the government side, the contractor doesn't realize that we messed up the option exercise, whatever it is. And a lot of times that can get much worse over time. The key one that comes up for me the most is, besides relationship issues and even kind of ultimately going to breach of contract dispute, something like that, is the False Claims Act component of a lot of this. And I tell people all the time, look, once you have knowledge, it's a problem, right? If you knew you were doing something wrong, you just discovered it, and for the last year you've been doing something incorrect, nobody knew beforehand, maybe that's an innocent mistake, but you now know that you've done something wrong and you just let it continue because you don't want to tell your manager or whatever it is, that can be a real issue for False Claims Act liability for contractors, things like that. And then on the government side, again, I referenced, I think earlier, that there was an option exercise and nobody really kind of said that was incorrect. And there was even a whole kind of dispute going towards breach of contract. And that was raised much later in the process. Whereas if the contracting officer just flagged that they messed up that administrative step, the government would not have spent a lot of resources disputing this issue and would have likely just settled it earlier, right? So I think the letting sleeping grizzly bears lie, it's attractive, but it often does not work out well for the contractor or the government.
Yeah, there's a famous quotation attributed to Colin Powell: "Bad news isn't wine; it doesn't improve with age."
Absolutely.
Yeah, and it's real. And there's an understandable but unhappy, unfortunate reason for a lot of that, and that is, and I'm really speaking from the contractor side, but it would be the same on the government side. People don't want to admit a failure which could then have personal repercussions. I've got to make my numbers. It's quarterly reporting, and this is going on. And if I reveal it, I'm not going to make my numbers. I won't have my job. or there's a cure notice. This is just a shot across the bow. The contracting officer doesn't really mean it. So, we'll figure it out. Rather than saying there's a cure notice, that's a potential first step toward termination for default. Let me make sure that I have all the resources I need so that I can address that cure notice and fix it and fix the problem. And those resources are things that I don't have control over, but my manager does. Well, that's why you bring them in. And then speaking as a lawyer, and this would be true both in-house and outside, but I certainly encountered this where people didn't want to get lawyers involved because they have a belief, usually false, usually wrong, that the lawyers are just going to make things worse and make them look bad. That's, in fact, in my experience and my attitude, not the case, but sometimes people bring that. And then the result, as Tyler put it, was things get worse.
And Fred, I think it is worth emphasizing that lawyers never make it a problem or worse. So we'll double down on that. That it's never a problem to bring us in at all. But no, I do agree that people get scared that it's going to formalize things and all of that.
I have to take one slight issue with that because I have encountered lawyers that have made it a problem. But they were always on that side.
Unfortunately. So that then leads to maybe some of those lawyers and kind of how they handle things. But mistake number 10, the common mistake is I chose to be right rather than happy. So people who really want to be right in that situation rather than getting the result that they ultimately deserve, I think. So could you speak to that, Fred?
Well, yeah, I have to first give credit to the judge I clerked for, Judge Bryant, who, when I was engaged and about to get married, and I learned subsequently that this was said to others as well when they were in that situation, said as you're getting married, you're gonna have a lot of situations where you can choose whether you want to be right or happy. And it's some of the best advice I ever got. But now putting it into more of a business context, even though government contracting is filled with rules and filled with laws and filled with regulations, and they're all very important, and as lawyers, we work with them all the time, it's still something that's done with people and relationships and personal relationships. And sometimes giving up on the small point, even though you might ultimately win, is going to do much better from a business standpoint in preserving that relationship. As one of my colleagues, former colleagues, once said, the negotiation is part of the performance. If you negotiate a contract and the negotiation is really intense and really negative, and you finally reach an agreement, that contract is already crippled. Whereas if the negotiation was smooth, the contract performance will be too. And that's true really all along the line. You need to protect yourself, whichever side you're on, you need to protect yourself and your company and your agency and so on, and you should and you will. But there may be lots of little things that are not really important, and you want to use your judgment about what you fight and what you don't fight. Another example of that is when people sometimes put bargaining chips. Actually, let me hold the bargaining chip one because we're going to talk about that later. But when somebody makes requests that they know can't be agreed to, there's situations sometimes arise in commercial business where people do that. But whether it's commercial or government business, if you're asking for things you know can't be granted, that's often going to undermine your ability to have credibility with the things that can be granted. So you want to make those choices.
Yeah, and I think, Fred, also when contractors look at this and I think it's typically more on the contractor side here because you'll be talking about the government's conduct, but sometimes you encounter people who are just livid about whatever the situation is, and they say, we're going to sue the government, this is outrageous, that kind of issue. But in government contracts, the three things I always immediately say are, well, what are your damages going to be? Because your damages are severely limited in government contracts compared to commercial contracts. Are you saying anything about the contracting officer acting in bad faith? Well, good luck with that, because I think there are, three cases. I mean, there are more than that, but it's very hard to prove bad faith on the contracting officer side. And then you have to continue performance whenever disputes arise, right? And so are you willing to have a terrible relationship for the next year and a half while we're litigating this, right? And so I think a lot of times when people hear that, they back down and realize, this was not the end of the world situation. This is something that can be managed and negotiated.
And one of the things about government contracting disputes, something that I like about it compared to commercial disputes, which I did for a while in my prior life, is that you're dealing with two parties that want to continue to do business with each other, with very few exceptions. The government contractor, they may be very upset about what the agency's done on this contract, but they want to continue to have that customer and have the government as a customer. And similarly, the government, unless there's some horrendous action the contractor took, they want that contractor to continue to do business with them. They want the competition and the support and so on. So you're dealing with two parties that in a way are pulling punches, not trying to destroy the other one. In a commercial litigation, very often, the two companies, once they're in court, they have gotten to a point where they never want to see the other again. They'd be happy if the other one went bankrupt. And so those punches are not pulled. And it can be strong, intense, and sometimes quite nasty. On the government contract, on the claims, protests, and other kinds of disputes, you're dealing with companies and agencies that want to continue to do business in the future. That makes it a more humane kind of exercise, but it's something we should keep in mind as we make the decisions about what to pursue and what not to pursue.
Absolutely, Fred. And so I think now maybe we should move into our lightning round of, it's the 10 most common mistakes, but now we'll do our 13 because we just decided to pack that in there. So do you want to go on to number 11?
Let's do it. And number 11 is really more geared toward the government. And that's where the contracting officer, who is ultimately the decision maker, sometimes doesn't use independent judgments, and particularly when dealing with the auditors, with DCAA. This is something that comes up where DCA challenges something and the contracting officer isn't willing to say, no, I disagree. Have you run into that?
Yeah, and I think it happens on the kind of protest side leading up to evaluations, and then absolutely during performance on the audit side. And I think they're two sides of the same coin, in that the contracting officer is responsible for the contract. They have to exercise discretion, make their judgment calls and all of that. And a lot of times, maybe it's based on lack of technical experience on the auditing side, or some scientific technical engineering standard, something like that. A contracting officer might feel uncomfortable and just say, well, I'm going to rely on the evaluation report on this area. I'm going to rely on the DCA audit report. And those are obviously very important things to look at. But at the end of the day, there does have to be and should be a independent confirmation of, does this make sense? Is this something I can support? Understanding I might not have all the experience relevant here. I'm the one who's ultimately responsible for it at the end of the day. And you see countless kind of protest decisions and issues in audits where a contracting officer just signed off and didn't think about, well, there's an obvious mistake in this rationale, and that causes a problem later on.
Been there, done that. And that just kind of leads to one of my favorite parts of the FAR, or actually just a single sentence. If you look at 1.602, which talks about what the contracting officer's job is and what their mandate is, one of them is safeguard the interests of the United States in its contractual relationships and, quote, ensure that contractors receive impartial, fair, and equitable treatment. Yes, they're going to be representing the United States, but they have a duty to the other side, which sometimes gets forgotten.
Absolutely. Now, for number 12 on our lightning round of the last three, you alluded to this earlier, Fred, and I'm glad you'll have a chance to talk to us about it. What about these situations where contractors might have a claim and they're trying to be a little bit on the commercial side, where they have something to negotiate and give away later on? What can happen there?
Yeah, lots of times in a commercial negotiation, you put things in that you're not going to get, just as to have something to trade. Got to be really careful if you try to do that in a government claim, because if it's a Contract Disputes Act claim, you're going to be certifying that you're entitled. You basically have claims made in good faith, and you're entitled to all the dollars you're claiming. Now, as long as you have a good faith basis to do that, that's fine. But if you don't, if any part of your claim is basically just a bargaining chip, then you may get hit with a couple of statutes that will make you very unhappy, If a claim is considered to be based on fraud, it's subject to forfeiture, and fraud can apply not just to something deliberately fraudulent, but just to a baseless claim. You may even lose not only the amount that you claim that was valid, but also the amount that you're claiming that was fraud. Let me give you a numerical example to illustrate that. It's the case of Daewoo. Daewoo had a contract, a cost contract where they filed a claim for $64 million. 14 million of that claim was meritorious. They were entitled to that money under the contract. The problem they had was that the court found that the other $50 million was not only not meritorious, it was a negotiating ploy. It wasn't made in good faith. So let's step back for a minute. What should have happened in a fair world, you would say, is, okay, they're entitled to 14 million, pay the 14 million. But that's not what happened. Instead, because they had filed that claim as, or the bulk of it as a negotiating ploy, they forfeited the $14 million. They lost all of it, even though it was a legitimate claim. But wait, there's more. Because not only did they forfeit the 14 million, they were also penalized for the $50 million negotiating ploy not made in good faith. So instead of getting 14 million, they lost 50 million. You know, I sometimes say, if you want a horse trade, be careful, you might lose all your horses.
Yeah, I think that's absolutely right, Fred. And the other areas I've seen just quickly are when people claim lost profits, essentially kind of going way and above what the termination for convenience clause would say, and they don't have a good faith claim for kind of a serious breach of contract outside of the FAR. And then also just, you know, not realizing sometimes that there's a cap in the termination clauses at the contract price, and people, again, on lost profits, things like that, try to go above, and you can get into some trouble there.
Yeah, if you know you're not entitled to it, don't just put it in thinking, well, it's okay, I'll give it up.
Yep.
Maybe worse than that. All right, we have one more, and that's for the thinking outside the box, failing to do that, failing to look for win-win solutions. That comes back to what we said at the beginning, that this contract administration shouldn't be a zero-sum game. We should be able to look for win-win solutions.
Yeah, and I think this mistake is my favorite on the government side and the contractor side. People get into their different camps and don't necessarily come together for a solution. And I think even before a dispute, right, even negotiating a contract, this kind of thinking can help out. That the FAR does recognize and state that whatever's not prohibited here or otherwise by law is something that the contracting officer can do. We talked about the discretion of the contracting officer to arrange contracts in a particular way, to decide issues of performance. And so if the parties can reach a creative solution to something and it's not otherwise prohibited, that's something that they can do. And so it absolutely comes up a lot for termination issues, for example, where there might be a disagreement, maybe based on different interpretations of contract language, and it looks like it's going toward a dispute, and the government's thinking they're going to have to terminate for default to protect themselves. The contractor is livid about that and is kind of pushing even stronger. And maybe a no-cost termination just handles everything for everybody, right? And that's an easy thing for people to just walk away. You don't necessarily have a bad performance record, things like that. So there are some issues that can kind of come up where both parties have interest in not having a problem, and there might be creative solutions. I love doing work kind of in other areas outside of the procurement context with other transaction authority agreements, things like that, and you have tons of room to maneuver and come up with creative solutions there. But even under the FAR, with all of its rules, one of the examples I've seen recently, and I don't think they've finalized this, but there are a lot of issues with advanced payments and cloud-based service contracts, essentially, where people are just reserving capacity to store or to process or whatever it is. And there's always a question of, well, if you pay for a subscription up front, is that an unauthorized advance payment under the FAR, all these kinds of issues. And it's just been plenty of guidance from GSA and others where they've tried to come up with credit systems, all sorts of different payment systems to make sure contractors get money, but the government's not violating the law, right? And that's the kind of collaboration that I think we're talking about here, is that it doesn't make sense to just say, well, I'm putting my head in the sand and it's easier to do nothing. Often both sides can come together and find a solution.
Absolutely, and this is one where contractors can really help if they are familiar with the rules and what is and isn't allowed. You know, Tyler, you mentioned the provision in the FAR that says if it's not prohibited, you can do it if it makes sense to both parties. And sometimes people on the government side are new, they're not experienced, and so they're not comfortable doing something unless it's specifically authorized. And that's something contractors can help government people grow into.
Great. So with that, we made it through our 13 common mistakes, the bonus 3.
Baker's dozen.
And we really appreciate it, Fred. Thank you very much.
Okay, thank you. Back to you, John.
This has been the PCI Practical Matters podcast. Thank you everyone for tuning in, and we hope you listen next time.